Welcome to The Explainer. So, have you ever wondered how a U.S. court gets its hands on crucial evidence when it's located halfway across the world? Well, it's not nearly as simple as you might think, and today we're going to unravel that very puzzle.
Okay, let's just dive right in with a scenario. Imagine you're in a huge lawsuit. The one thing you need to win, that key document, that star witness, is sitting in another country. How on earth do you legally get what you need? It seems like a simple question, right? But the answer is anything but.
Yeah, you can definitely forget about just sending an email or making a quick phone call. We are talking about a seriously tangled web of international treaties, questions of national sovereignty, and high-stakes legal arguments that have gone all the way to the U.S. Supreme Court.
And look, in our totally interconnected world, this isn't just some abstract legal theory. It's a real, practical problem that companies and people run into all the time. So let's start by breaking down exactly what this cross-border challenge looks like.
The bottom line is, a U.S. court's authority kind of stops at the border. You can't just send a U.S. marshal to, say, Paris to demand a document from a French citizen. Every country has its own rules, its own legal system. And that's precisely where international agreements have to step in.
So how do you bridge that gap? How do legal systems talk to each other across borders? Well, for our story today, the answer lies in a really important international agreement known as the Hague Convention.
The easiest way to think of the Hague Service Convention is like an official, super secure, government-approved postal service just for legal documents. Its entire job is to make sure that when you sue someone in another country, they get the official paperwork properly in a way that both governments recognize as legit.
In the process, on the surface, seems pretty straightforward. Your lawyer sends the legal papers to what's called a central authority in the other country. That government body then formally serves the document, and you get a certificate back proving it was done. It's a system built to be reliable. But, and this is the million-dollar question, what kind of packages can you actually send through this special service?
That exact question ended up being the focus of a huge legal fight. And that brings us to our case study for today, the water splash case.
So here's the setup. You have a U.S. company, Water Splash, that needed evidence from a guy named Menon, who was in Canada. So they tried to use the Hague Convention to serve him a subpoena, which is basically a legal order demanding that he produce evidence. But Menon's legal team pushed back hard.
And this is where it all came to a head. Water Splash argued, hey, the convention's rules let us just mail this subpoena. But Menon's lawyers fired back, saying, no way. The convention is for serving the documents that start a lawsuit, not for demanding evidence in the middle of one. The entire case hung on that single point of disagreement.
Now, this might sound like a technicality, but the implications for international law were absolutely massive. So massive, in fact, that this case worked its way all the way up to the U.S. Supreme Court.
And when the Supreme Court finally issued its ruling, the verdict was totally unambiguous. They sided with Menon. The court made it very clear that, in their view, subpoenas are a fundamentally different animal from other legal documents. The court basically drew a bright line in the sand. They said that for the purposes of this specific treaty, a judicial document is the piece of paper that formally kicks off a legal case. Think a summons or a complaint. It's the document that says, hey, you are being sued.
See, a subpoena isn't the starting gun. It's a tool you use while the race is already underway. And because of that distinction, the Supreme Court ruled that you cannot use the Hague Convention's main channels to serve one. The short version? You can't use this treaty to force someone in another country to hand over evidence.
Okay, so why does this all matter? I mean, it sounds like a bunch of legal jargon, right? Well, this ruling is about way more than just paperwork. It's really about the limits of power and the respect for national borders.
So let's just nail down the key takeaways here. First, the Hague Service Convention is for one main thing, serving the initial papers that start a lawsuit. Second, you absolutely cannot use it to serve a subpoena to demand evidence from someone abroad. To do that, you have to use different and, frankly, more complicated tools. And finally, and this is maybe the most important part, this distinction acts as a kind of shield. It protects people in other countries from the direct, compulsory power of a U.S. court.
It's a really powerful reminder, isn't it? We live in a world where information, money, and ideas can cross borders in the blink of an eye. But legal power? That's a different story. The lines on the map are still very, very real in the eyes of the law. And it really makes you wonder, in this hyper-connected age, are our legal borders actually becoming more rigid than we think?